Okay, please, your lordships. My lord, item number 4, adjournment slip was circulated yesterday on behalf of the amicus, my lord.
Okay.
He's out of station, my lord. The matter may be posted after 2 weeks.
It is Mr.
R.B. Goswami, my lord,
R.B. Goswami.
on behalf.
Mr. R.B. Goswami.
My lord.
Learned counsel representing Mr. N. Hassan, learned amicus reporter, appellant has submitted that Mr. Hassan is out of station on personal ground and a mentioned memo for adjournment has been circulated yesterday. Also, Ms. A. Begum, learned additional public prosecutor, appearing for the respondent state, has submitted that the state has no objection. The prayer of adjournment. Also, the prayer is allowed, like is after 1 week.
After 2 weeks, my lord. Okay.
May I please your lordship? Lordship, I beg to mention IA criminal for orders, lordship.
Item
No, lordship, I beg to mention for listing, lordship, IA criminal.
I criminal for what?
For lordship, the appellant is in jail from last 10 years for orders, lordship.
Okay, orders.
I beg to mention, Lordship, I beg to mention for listing of criminal appeal. Last it was listed on 20th of May
For
for orders
side you.
of last Lordship.
Supplementary list for orders. Item 7.
May I please your Lordship?
Oh,
And there is a IA, my lord. Considering the length of detention, I have filed the IA, my lord, because it's a conviction for life.
yes.
And my lord, I have to submit 4-5 points. So matter may be fixed for hearing, my lord.
Are you pressing this I or not?
Yes, my lord. I am pressing first.
And then why hearing?
First, that's why I mentioned my IA first. I mentioned my.
No, don't. There cannot be two-prong attack.
Okay.
We have fixed it for this one.
The accused
I admit your submission.
behind the bar till since my lord 9/3/2023, my lord.
That cannot be a ground.
Hello. I have said on.
Presumption of innocence is gone.
There is eyewitness.
So that cannot be a ground.
My lord, eyewitness. There have 4 person, my lord.
Hmm.
There was on one another other person also. Eyewitness, which statement was not recorded.
That is whether there is sufficiency or insufficiency. Whatever prosecution has done, whether those things are sufficient or not. That is the issue.
My lord, kindly
You
peruse-
cannot
kindly
find fault with the prosecution, whether prosecution has been able to prove the case or not.
No.
Now,
My lord, kindly
confine your submission on within 389 jurisdiction, that's all. Don't go here and there.
I have filed it. I only the length
Hmm?
length of detention on the basis of length of.
That cannot be a ground for 389. In view of this prima facie evidence, yes.
My lord,
How many witnesses were examined?
8 witness was examined, my lord. My lord, may kindly peruse first page number 4, the FIR.
8. Okay.
4, the FIR, my lord.
FIR.
FIR was lodged by my lord Lavanya Kumar Bora, the assistant manager.
Hmm.
He was hearsay witness, my lord.
He was reported witness. He doesn't have his own personal knowledge. No doubt about it. He got the information only
From
from
Basanta Gogoi, my
Basanta
lord.
Gogoi. Let us concentrate on Basanta Gogoi.
My lord, first, currently here is the first statement, my lord, in page number. Just 42. My lord, may I kindly peruse the 42, page number 42. May I read, my lord?
Hmm.
My name and address as mentioned above are true. About 4:30, 4:45 p.m. on 28/2017, I and Dilip were walking as Sokidar in section number 39 of Bogabag Tea Estate. At that time, on seeing Buddha Sinkumura was another person, not the accused person, my lord, stealing raw tea leaves. He saw Buddha Sinkumura to stealing raw tea leaves, my lord. Both of us apprehended him and then we took him along in order to hand him over to VTP secretary. After going some distance, Badal Chinkumura come towards us with a naga dao in his hand and hacked Dilip Das, who was with me, my lord, on his left hand and neck, thereby injured him. I raised an alarm and ran from there in order to inform the matter to VDP secretary and other neighboring people. Buddha Sinku Mura, my lord, the another person, said that Badal Chinku Mura was also involved in the act of stealing raw tea leaves. That means, my lord, Basanta Gogoi have not seen directly, my lord. He was also informed by the Buddha Sinku Mura, my lord. That on seeing us, he fled away earlier. He was fled away earlier, my lord. In the meantime, Buddha Sinku Mura fled away. Badal Sinku Mura fled immediately after the incident. Dilip Das died in the hospital on that day itself. According to this statement, my lord, he have not seen directly, my lord. And
How can you say that? Page 43.
my lord,
Badal Sinkumura came towards us with a nagadao in his hand, hacked Dilip Das, who was with me,
my lord,
on his left hand and neck,
my lord,
thereby injuring him. I raised an alarm
my
and
lord,
ran from there. Then said Badal Sinkumura fled immediately after the accident.
my lord,
And what is the charge?
my lord, then again come to second statement of Basanta Gogoi, my lord, in page number 10, my lord.
This is not statement, this is
It is
evidence.
evidence, my lord. In his evidence, he said, in third line, my lord, we saw that accused was stealing green tea leaves.
Hmm.
We saw that accused was stealing green tea leaves. Me and Dilip asked him not to steal leaves. His statement is contradictory, my lord. Then he cut Dilip on his neck and hand by a da, which was not recovered, my lord, and which was not seized. Office in charge has admit this, my lord. I will prove. I saw that I plead shouting after I crossed some distance, my lord. Then, my lord, in last paragraph, in his cross, he specifically mentioned, my lord, accused used to work at our tea estate as worker. Accused steal 30-40 kg green tea leaves, which police seized. I saw the weapon of assault, which was Nagada 40-50 local peoples come out, my lord. Nobody has seen, my lord, the dao, which was not recovered, which was not seized. That's why, my lord.
Now, what is the law? Non-recovery of the weapon. In the face of direct evidence. There is a case, this man has deposed as an eyewitness, and his presence at the place appeared to be normal, natural, because he was a chokidar along with Dilip Das. He was a chokidar, is it not? Bogabag Tea Estate.
My lord,
The disease was also a chokidar.
my lord, in 313 statement, he has stated that he was not present. He has not took any name, my lord, but he was not present. I will show you, my lord. My lord, kindly present office inserts statement, my lord. Yes. In page number 20, my lord. 20. In my lord, third paragraph, last line, my lord. Last line, I also recorded the statement of eyewitness Buddha Mura. Buddha Mura's witness was not recorded, my lord. He was also present that point of time, my lord. And his cross-examination from third line, he said, I did not make any seizure of the tea leaves. I also cannot say its quantity. During investigation, it was revealed that the accused dealt blows by Dow, but I cannot say the exact specification of the Dow. As the Dow was not found, it could not be seized.
What about the witness, this PW3?
PW3 also, my lord, here's your witness. Moni
No,
Das.
not exactly.
No, my lord. She has mentioned.
Have you read section 6 of the Evidence Act to submit this kind of submission? Hearsay evidence is otherwise not admissible, but there is an exception.
No.
This testimony of PW3 comes within that exception, as well as that shopkeeper. PW6.
I know that I also know the incident took place 4 years ago. I was in shop located near my house.
I saw Dilip Das coming towards his house from the hillock. He told me that Badal attacked him. I saw the accused running away.
No, my lord, not accused, victim. I saw Dilip Das, victim,
Yes.
coming down towards his house from the hillock.
Ah.
He told me that Badal
Ah.
had hacked him.
Evidence Act.
I just want to pair, sorry, my lord, may kindly peruse page number 26, my lord. I just want to point
Section
out
6.
26, my lord. 3132 statement, my lord. In the last paragraph, my lord, do you have anything else to say? I just want to point out, my lord, Basanta Gogoi implicated me. I was not present there. He could have took Basanta Gogoi's name.
No,
and Basanta-
madam, take us to the cross-examination. Whether such plea was taken one by one. PW1,
My lord,
PW1, nothing. PW2,
Basanta Gogoi.
not Basanta Gogoi.
PW,
That you were not present.
my lord, not,
Ah?
not,
Then
my lord.
PW3,
Nobody was present that point of time.
no, your suggestion, madam.
My lord. Oh, 26, page number 26.
Set 26 is 313.
330. I
No,
just
come to cross-examination part, whether any such plea was taken at any point of time, madam. Trial continued from 2017 to 2022, 5 years. Did you take any plea during these 5 years? By any kind of suggestion even? Not to speak of any evidence. Any kind of suggestion. That was not there. Even by way of suggestion that I was not present. No suggestion even. At the end, last question, answer. Then if you are not present, then it appears to be a kind of plea of alibi. Plea of alibi you have to prove by defense evidence. For the time being, we don't find anything in 389. Good night. Illustration A, section 6. A is accused of the murder B by beating him. A is Badal Sinkumura. Badal Sinkumura is accused of the murder of B, Dilip Das, by beating him. Whatever was said or done by Badal Sinkumura or Dilip Das or the bystanders at the beating or so shortly before or after it as to form part of the transaction is relevant fact. Yes, madam.
Chief, eyewitnesses are there and autopsy also corroborated at this stage.
We could have brought this Buddha by better cross-examination.
There is nothing.
Buddha Sinkumura, you could have brought the presence of Buddha Sinkumura, and he was the main person behind lifting of tea leaves. You could have brought it by better defense. Only defense. Asikur Rahman. Hard. MSM Das.
Legal aid counsel.
Learned legal aid counsel for the applicant appellant. And MS A. Begum, learned additional public prosecutor for the opposite party, comma, state. First of the instant application under section 389 within bracket 1 Code of Criminal Procedure 1973 within bracket the code order CFTC for short is preferred, seeking suspension of the execution of sentence, suspension of execution of the sentence passed against the applicant appellant and for release, for his release on bail. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal, criminal appeal J number 97 of 2023 against a judgment and order dated 9/3/2023 passed by the Court of Learned Sessions Judge Soraidev in Sessions CHS Chaw, page 30, case number 23 of 2019. Full stop. By the judgment and order dated 9/3/2023, the applicant appellant has been convicted for the offense of murder under section 300, IPC, and he has been sentenced under section 302 IPC to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, comma, in default of payment of fine, comma, to undergo simple imprisonment for another month. First of para. Learned legal aid counsel, appearing for the applicant appellant, has submitted that the evidence stroke materials on record go to indicate that there was presence of another person named Buddha, Buda, Sinku, Sinku, Mura. And that person was actually involved in stealing of raw tea leaves. And full stop. On the said aspect, comma, there is inconsistency between the statement of the alleged eyewitness, comma, Bosonto Gogoi, recorded under 164 CRPC, and the deposition of Bosonto Gogoi as PW 2 before the court. So, in view of such inconsistency, comma, the applicant appellant should have been entitled, should have been granted the benefit of doubt. Full stop. Para MS Begum, learned additional public prosecutor appearing for the state, has contended that the testimony of Bosonto Gogoi as PW2 remained unshaken, and his testimony received sufficient corroboration from PW3 and PW6, whose evidence are admissible under the rule of res zestia, RESCESTAE. Full stop. MS Begum has further contended that the evidence of these prosecution witnesses are the medical evidence as regards injuries sustained by the deceased is in conformity with the ocular testimony of these prosecution witnesses. First of all, we have considered the submissions of learned counsel for the parties and have perused the material stock evidence on record to appreciate to consider the submissions, to consider the rival submissions, Full stop. Para. The prosecution case, comma, in brief, comma, is that in the afternoon hours on 28, 2017, comma, the accused the applicant appellant, that is the accused, had hacked one Dilip Das, that is Commander deceased, who was a chowkidar in Bogabak division of Kanu Tea Estate. Full stop. Para. One Osonto Gogoi. PW2 testified as an eyewitness. Full stop. Bosonto Gogoi deposed to the fact that he was a chowkidar of Bogabag Tea Estate, along with and the deceased Commander Dilip Das was a colleague. Dilip Das, who was also a chowkidar, was his co-employee. Full stop. As per his testimony, at around 4:40 p.m. on 28/2017. When both he and the deceased were on duty, they found the accused stealing green tea leaves. Full stop. When the accused was questioned, the accused cut the deceased on his neck by a dao. Full stop. Seeing the assault, PW2 stated to have fled from the scene, shouting. Full stop. Immediately thereafter, the accused which blood all over his person, also reached the place. Full stop. At that moment, the wife of the deceased, Moni Das, within bracket PW3, arrived there and asked the deceased about the matter. Full stop. The testimony of Moni Das, the wife of the deceased, who testified as PW3, corroborated the testimony of PW2 as regards the time and date of the incident. Post of PW3 stated that she saw her husband coming towards their house, having blood all over the body and falling on the road. Full stop. PW3 further stated that when she asked about the matter, she was told by the deceased that the accused had cut him. Full stop. The testimony of PW6, Rahul De has supported the testimony of PW2 and PW3 to the effect that he saw the accused coming down towards his house, and when he asked the deceased, he saw the deceased coming down. When he asked the deceased, he was told by the deceased that the accused had hacked him. Full stop. All these three prosecution witnesses stated that they saw injuries on the neck and hand of the deceased. Full stop. The PW6 further stated that he saw the accused running away from the scene. Full stop. Another. The evidence of the testimony of PW3 and PW6 are prima facie admissible under Rule 6 and Rule 8 of prima facie admissible under the rule of evidence embodied in Section 6 and Section 8 of the Evidence Act. So stop. The medical evidence in the form of testimony of the autopsy doctor, PW 8, and the postmortem examination report, EXD6, are found in conformity with the testimony of the prosecution witnesses, PW1, PW2, and PW6. Full stop. Para, in considering an application under 389(1) CRPC involving a serious offense like murder, punishable under Section 302 IPC, the court is required to consider the relevant factors like the nature of acquisition made against the accused, the manner in which the crime is alleged to have been committed, and the gravity of the offense. Also, having considered the evidence materials on record on the aforesaid aspects, as discussed earlier, we do not find any merit in an instant application preferred under Section 389(1) CRPC to extend the benefit of suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Post up. As the application is found not merited, the same stands rejected. Post up. The observations, it is made clear that the observations made herein above are only for the purpose of consideration of the application under Section 389(1) CRPC, and the observations made herein shall not construed to be an observation in respect of the merits of the accompanying appeal, and the same shall not have any bearing in the outcome of the appeal. Next. Third, MS M. Das, learned legal aid counsel for the appellant, and Mr. MS A. Begum, learned additional public prosecutor for the respondent state. Full stop. As the paper book is ready and the learned counsel for the parties have received the same, office to list the appeal for hearing in due course.
Obligement.
Third method for hearing, item number 8.
MS Nargis, you have 1, 2, 3. We'll take up this part matter first. And we don't know next, if the council is available, there are 2 fixed matters. One is in the one is item 5. If the council is available, that person is in jail for 21 years. You are 4, 5 years.
9 years.
Okay, next preference. But so far as item 5 is concerned, he is for day, not he, about 3 of them, I think. It has council is available or not? You are available? Okay.
2 appellants are there.
2. They are in jail for in jail, and the imprisonment is consecutive.
Oh,
Consecutive.
I'm here, Lordship.
So we'll take up that next.
Lordship.
But here we'll part matter first. So I don't think there is any possibility in the first half.
Lordship.
I'm making it clear so that you can do your other business in other courts.
Lordship. Hello, Lordship.
Yes.
Your Lordship has asked that whether if the victim filed a complaint in the court instead of going to the nearest police station, whether any judgment is there. So I have found one Madhya Pradesh High Court judgment. Lordship.
Let us see.
Where in this case, she went to the court, drafted the FIR and typed it out, and that was taken into consideration. That aspect. Although it is a single bench judgment, Lordship.
Yes, we can take notice of it.
Lordship. In paragraph 6, it is mentioned.
The evidence. Documentary evidence for file 2. Heavy. Turn it down. It can negative, obviously. Took adjournment 4-5 times. Consecutive sentence.
I am going-
Consecutive sentence, meaning thereby how much? Like this one, he is 27. But your case is remainder,
For the life.
20 years old. And you sought adjournment.
Actually, I am going to outside for medical issues, Your Honor. That's why actually.
We'll start tomorrow. We'll make the beginning tomorrow.
I'm going tomorrow.
Huh?
Your Honor, I'm going tomorrow morning, actually. That is why. Your Honor.
What?
She's
To-
going out for medical
For
checkup.
my mama's treatment. That is why, Your Honor. Maybe fix on next Thursday, Your Honor.
We fixed some cases already, no? Next week. Some একে ভূঞা এটা কৰিছো হা একে ভূঞা এটা কৰিছো নেকি কিবা এটা N Mahajan. Then we'll miss the bus. You are only on the council. Oh, you are legal aid council.
I'll come back by Wednesday, so kindly for Thursday.
Okay, just Thursday,
of like-
as requested by
next week.
MS R Goswami, Learned Legal Aid Counsel for the appellants, comma, not objected to by MS P. Bhuyan, Learned Senior Counsel and Additional Public Prosecutor for the respondent state, comma, list the appeal on
12/9.
Thursday.
12/9.
Yes, madam.
My one is 1, 2, 3, my lord.
We'll put it after a week. Next week, we have, I don't know, we are sitting or not. But we are posting a few matters next week,
Can it be lordship on Tuesday, lordship?
not Tuesday. Tuesday fixed 2 or 3. Only Thursday was available, that was filled up by this last case. We can post it, but precedence will be given to that. We can post it on Thursday, but precedence will be given to that case. With the understanding. Because that is about 21 years. You are 8, 9 years. Okay,
In that case, my lord, our IA is pending, lordship. Lordship,
no, we do, when hearing is fixed, we are not taking up IA. If you want to praise the IA, we'll post it on miscellaneous day, not in hearing day.
already fixed for hearing 8, 9 years, they are inside the.
So better you wait. We'll give you preference. Actually, this period of detention should have been mentioned.
Yes.
Only 5 years is mentioned.
Various is mentioned because from the date of filing, date of judgment. It's a case of 2016.
Okay. After 1 week then. Due to paucity of time, the appeals could not be taken up today. Full stop.
My lord,
MS Nargis, SK Nargis, Learned Counsel for the appellant. And MS,
case number 1, 2, 3.
your name please.
Z Borua.
Huh?
Z Borua.
G. Borua. You are standing counsel. Oh,
Yeah.
for Cal,
Of SC government.
Learned Counsel, representing Mr. S.C. Kahal, comma, Learned Public Prosecutor, NCB, are present. Also, list the appeals
Thursday, lord.
after 3 weeks, or after 1 week, after
Lordship,
1 week.
kindly fix it Thursday if possible, then
1 week, 1 week. I gave you opportunity, you did not took.